All right, good morning, family. I hope you are here and ready to go. Do I need to be looking this way? No. Oh, okay. Well, I can look here because I want to be able to look at the questions. So, family, this is Shannon Jackson, your girl, the people's nurse. How are you this morning? And I am excited. I'm actually live here at Miss Maria's MVP office. I call her attorney extraordinaire. Good morning, Maria.
Good morning, Shannon. I love your energy.
Oh, thank you so much. Thank you so much. Well, we are here today with purpose. Family, if you don't know and you haven't been around and you're just joining us for the first time, welcome. But today we're going to be talking, I'm calling it estate planning 2. Because we've done a video before multiple times now, but I wanted you, the viewers and listening audience, to bring your questions forward. And actually, I've already have some that came through email and came through texts that's going to start this. But we're going to be taking your questions via the chat, and I'm going to make sure I can see them all. And I'm going to ask one of these production people to help me. Where can I see my text check, my questions at on here, fellas, so I can make sure that I don't miss anything before we get going? I'm going to be able to see my questions that come up. I'm going to start it off. Where are my questions here? Oh, there it is. All right. So I want to welcome everyone in. And if you're in here, make some noise by giving me an emoji. Yes, a thumbs up that you're in the audience here, because we are so excited to bring this. This is, we talk a lot about health and wellness. You know that with my background being a registered nurse. But we're not just concerned with living your life without limits about health and wellness. We're concerned about the total individual. And financial health is important, especially in the times that we're living in now. And you know what? There's a scripture that said, my people perish because of lack of knowledge. And I am going to admit, in the minority communities, African American and Latinos primarily, we are ill-informed as it relates to financial management, not only in life, but in death and when we are ill. And many of us have seen the GoFundMe pages and fund me this or lend me, give me, can you spare, or everybody putting a collection plate together because there is no money or no planning. So without plans, family, purposes are defeated. And I don't care if it's planning for your wedding, planning for your future, your career, but now we're talking about estate planning. So today, I want to make sure that your questions are being answered and you're being heard. And guess what, family? Miss Maria, as I'm getting ready to open this up, because she understands the importance and she's like my sister from another mother, every last one of you, if you contact her office between now and July the 31st, you will receive 25% discount off of all estate planning services. Let me say that again, 25% discount. Come on now. You can't beat it with a stick. So make sure you're listening and being attentive and get your questions ready, because we're getting ready to dive in. Are you ready, Miss Maria?
Let's do it.
All right. So the first question, and I thought it was a great one because it hasn't come up before. Is a living trust transferable from state to state?
Well, indeed, good question. So basically, when we create the trust, when our clients come to our office, we have to establish residency.
Okay.
Because living trust can be created in all states, and it's better to create. So when California residents come to my office, we create a living trust for them based on California laws and regulations. And sometimes my clients move, especially lately with everything's going on here in California. And yes, the trust is transferable. Let me go a bit deeper.
Sure.
So So often people have real estate, for example, properties, not only in California, but nationwide in different states. When we create a trust here in California, we also, then the next step is to fund this trust, to transfer title of your property wherever it's located within the United States, usually, to the name of this trust. So we file documents here with various counties where the property is located, and also we file certain documents in different states, because even if you don't have a plan and you have to go through probate process and you have properties in different states, probate process has to be opened in all those states where property is located. So let's say you have house here in California, and your family's residence in North Carolina, Louisiana, who knows where. If no plan exists, you'll have your heirs, whoever is next of kin, will have to start the case, probate case here in California, and also in that state where property is. That means hiring a local attorney, paying local fees and taxes, and all that's concerned about. So, and you have multiple properties in different states. That means everywhere where a property located, the probate has to be opened to transfer the trust. I do recommend my clients to, when they move, to seek counsel of a local attorney to take a look at this trust, California trust, and see if, because different states have different laws. And some states do have a state tax. Here in California, we don't have a state tax.
Well, thank God, because we got tax for everything else. So that's good.
Keep it quiet. Don't give them ideas.
Please don't. They already going up on the gas. They going up on this.
So don't give them ideas. But you should at least have a consultation with a local attorney to see if any changes have to be done.
Okay. So possibly it can be transferable,
Yes.
but it may need some amendments.
Exactly.
That's a very good question. Okay, before I answer another one that came forward, is there anyone that's currently online that have a question before I go one of these that came up before we got online? Let me see. Anybody got any questions there?
Bring it on, guys.
Come on, bring them on. We got 1 hour with Miss Maria, and we want you to soak this in. I don't have to mention your name. I can just mention the question. I want you to get your answers told. Here's another one. They're percolating. They're percolating those questions.
Okay.
That's all right. Here's another one that came up. They were heir to a trust, and there is concern that the person that is over the trust is not acted in the proper interest, or maybe did some funny business in the trust. How do you handle that? You don't actually have proof, but now everything has shifted. There's suspicion because there was someone else over the trust and they got removed without notification. So the question came up is a two-part question that came up. When the trust was originally put together, every one of the heirs received a letter, and they said who was going to be over the trust. That was the original. Then when the person died, they were told that the trust was amended and someone else was over it. They wanted to know, were they supposed to get notification? That's the first part. And the second part, they're concerned that all the assets that was supposed to be in the trust, the person that's over it now saying that was not part of the trust, that they have 100% that, and that's going to take a couple of years before things settle. So it's a two-part question.
Okay, so it does happen, unfortunately.
Okay.
That is why in my trust, when I create the trust, I offer my clients to appoint a trust protector. It's
I like that.
third position of a person who is not active until somebody triggers the situation. Usually I insist on it when there's blended family situation, yes, or if there are minor children involved. That's, I always insist on doing it, because you need someone to be able to slap on the wrist the other person. And that trust protector, for example, sometimes people name me as trust protector. And when things like that arise, I can be not contacted by a beneficiary saying, hey, Maria, I suspect some wrongdoing going on.
Right.
Then I can step up. I have a lot of powers to bring everybody in, ask for accounting, ask for all the documentation, instruct them what they have to do, tell them that you can be removed if you're not doing what you're supposed to do, because the executor or successor trustee has the highest fiduciary duty to act in the best interest of the trust and beneficiaries. So it is actually fraud if they're and offense if they're doing something not what they're supposed to do.
This is a very good point, and I believe, and I will tell you, family, I'm amending mines now in the process of with Maria. I finally got my questionnaire completed. And what have
They want to look at the camera.
Oh, they want me to look over there? Oh, I'm over here looking. Well, how am I going to know where to look over there? Oh, right here. Oh. All right, y'all, we live, so it's all going to be on there. They want me to look here. So, and one of the things that I'm going to do is add a trust protector, because when I looked back over the original trust that I had, I did not have that. But when I heard about this story that came through a question, I said, this is very good, because you had brought it up in our prior meeting. So here's another question that came up.
No, can I follow? Because
Yes.
we didn't finish answering.
Yes.
So usually when creator of the trust dies, the trust becomes irrevocable. So nobody can change it, usually, unless specific powers are given in a trust. And successor trustee, so when beneficiary dies or when the grantor dies, the next person comes in to administer the trust. And sometimes there are provisions who and on what terms can fire basically this successor trustee if they're not doing the right job. And you as a beneficiary should have received notice from the trustee saying, hey, the grantor died, with the parent or grandparent or whoever, and here's a copy of the trust. You're supposed to have a copy of the trust delivered to you within 60 days of death. And if you have not, you can recourse for you is to hiring attorney to contact the successor trustee. And as a beneficiary, you have right to accounting by law. It's written in statutes and books. So, letter saying no can be sent to the trustee. Maybe that will be sufficient, and they'll know that there's something to check them.
Wow. So that may bring up to the question, you may have already answered it, but I want to make sure. Chanel brought a question. What happens if the trustee dies or becomes incapacitated?
If the trustee, I assume it's not the original grantor.
Right.
It's successor trustee. When he or she dies, usually I almost make people to appoint several people in line. Who do you trust? So my first choice is, I don't know, my niece.
Right.
My second choice is my brother-in-law, people who I trust to administer the trust.
Okay.
And but sometimes I review trust and there's no such language. People appoint one person and that person is dead now or incapacitated. Then should be within the trust documents how that another successor trustee can be appointed, either by vote of the beneficiaries, or they may instruct you to ask the court to name one.
I was going to say, as a follow-up to that question, so say it is only one person and they did not appoint a second or third. This time I did that. I appointed second and third because I thought about life is changing and things are happening. But if they didn't, does it end up going into probate?
No. What goes to probate is that beneficiaries have to come together or choose one person in charge and ask the court. Again, it depends what's in that trust document. As I told you, they could have given instructions about the committee who chooses the trustee, or you have to go to court. If not, none of these languages exist, then you have to go to court, say, hey, judge, here's our trust. Successor trustee passed away. Please appoint who do you think is the right person.
Okay. Now, I have a question here. Can a trust protect me from debt collectors? That's a good one.
Very frequent question I receive.
Because a lot of celebrities do that. They hide. They say they broke and they're not broke.
Yes, it is possible. There are various. So let's talk first about the regular trust, a revocable living trust that people create to avoid the probate and make life easy for their beneficiaries. That type of trust does not protect you from creditors because you, as a grantor, establish it. It's still under your social security.
Okay.
And you still can have the power over assets or over this trust. So let's say there's a creditor, they file a lawsuit, they win a judgment against you. They can tell you, hey, take this asset out of the trust and pay us, or put a lien on the trust. It is harder for them. They have to jump couple of more hoops.
Spend some money too.
So it depends on the creditor's aggressiveness
and how much money is at the table.
So that can be touched.
Yeah.
About the other option you were talking about, celebrities, quote unquote, hiding. It's not hiding. It's finding legal ways to shield your assets, things that you worked hard all your life, and. You may be running a business and you may have made the wrong business decision. So your family doesn't have to suffer. Only your business has to be, can answer for those debts. That's why when I talk to my clients, I look at overall picture, all the businesses, all the assets that they have. And we do some extensive planning, like asset protection planning. Mm-hmm. That's another level. To shield some of the assets from possible future creditors. Okay. And we can create, and one of the options is to creating an irrevocable trust. For example, you have your multi-unit building, and we can put it separately in the trust that you know that you want to live for your family as an income stream for future generations, and have it run by separately. But that of course involves more costs and that more management, because if you want to protect yourself, you have to do something for it.
Right.
So there are possibilities.
Okay. Now here's one from Tricia. Says, what are the tax implications of trust accounts for both the trust and the beneficiaries? That's a good one too.
That's a good one. Usually,
they're all great questions.
However, for these types of questions, I send people to the CPA they work with, or I work with, if they don't have the right one. But tax implications are that it is beneficial for a married couple to create a living trust because of the step up in basis. Because at the time of the first death, there are certain tax benefits so that the value of the property can be, stepped up from the original. That it's a bit. We can have the whole just on the whole presentation on that. So it is better to have trust for tax purposes, especially for higher net worth people, because when there are multi-million-dollar estates involved, and what is multi-million-dollar here in California, especially here south of, so several couple of houses, depending on the location, some savings or stock account. Here you go, you have $2-3 million. Now, death estate tax, federal here in California, it's federal is over 12 million. So it doesn't concern most of the people.
So the beneficiaries are not taxed on trust?
No, hold on.
Okay.
So usually not.
Okay.
Because now it's over 12 million, and very few people
running around with 12 million.
Because my clientele is middle class people. Okay. I want to help lower class people who have their own house. They worked so hard. I want to make sure that it stays with the family and they're protected. They don't have to spend their last money from the bank account to go through probate. Okay. But for those who have a higher net worth, that 12 million sunsets at the end of 2025. And we suspect that it's going to come back to either 3.5 million or 5.5 million. So what is 3.5 million here in California? It's again one or two houses plus some accounts plus some of because we count all the assets that you have at the time of the death. And if your net worth is higher, then you pay taxes for what's over that limit, and it's almost 50%. So for those people who have a little more, have businesses, you have accounts, you have your assets, you work hard, you're a businessman or woman, you have to think about future. You have to think that, make sure that you're not just keeping those 50% of whatever is over the limit for IRS.
Use it, spend it.
No, or utilize techniques to spread it around. Asset protection to make sure it's not taxable at the time of the death.
So if any of you are getting over 12 million that are out there, make sure you come and see Miss Maria, because she'll help you protect that 12 million for generations to come. But you don't have to be at 12 million. If you have your car and that is your only asset, you don't want nobody fighting over that. So this is information that is needed. So here's a couple of more questions. So here is one that says, what are the legal requirements for setting up and managing a trust account?
You have to be alive and be cognitive, because I have to establish that you are
have capacity
and
mental capacity,
can make legal decisions, and have your picture ID, social security, basic forms, and come here, go through the process, and we create the trust and fund it, and you live happily ever after with peace of mind. I mean, there's no legal requirements per se. We have to do it properly, go through all the process. It has to be notarized, witnessed at certain, depending on positions, and being alive and cognitive. It's very important, because on Thursday my assistant and I, we went to the hospital where there was this lady on dying bed, and thank God we were in time, and she barely had her strength to sign the documents, and she could nod yes or no, and it was literally last minute. So don't wait for that.
Exactly. So Trisha, are wills a thing of the past in the sense that trusts are better? If you do not own anything, should you have a trust? Very good.
Very good question. Thank you, Trish. Here in California, so if you have any property, your assets worth more than 160,000, then you should have a trust.
And that's even if you own property, family. So in other words, if it's not completely out of debt and you have equity in your property, you want to have a trust.
Yeah,
am I right?
Yes, they look at the value of the house, not how much you own of it.
So Larry Lala, you got more than $12. You got assets. You own a house. Larry making it fun.
So wills. Yes, about asset protection, people, first thing that comes into mind, I can write a will on a napkin, have my buddies at the bar witness it, and we're good enough. Yes, wills still work if you have assets for less than 160,000, and also wills work, especially for people with young children. Because in the will you can name a guardian for your kid. That's why I help not only multi-million-dollar clients, but single moms who have their child in a bank account. You have to have some planning. The question to everybody right now, as things stand now, if you're not coming home today, how's your family gonna be? Is it gonna be peace of mind, or it's gonna be chaos and your legacy? Especially for guys, you guys,
Yeah.
you're for your family. You're kings. You bring your lines. You bring, you protect. So make sure your family is protected, even if you're not there.
And let me say this, a lot of people, just to add to this, even bank accounts. If you pass today and you haven't named a beneficiary on your bank account or don't have a trust or will that appoints somebody to go in, it's hard to get the money out when the person died. Some banks won't even give it to you at that point. You have to have some legal way to go in and say, get John Smith's money because he's no longer there. You weren't listed as a beneficiary on the account of the person. So it's things like that that you come in and somebody can help walk you through those processes, Maria and her team, to tell you about those different things. Because say all the money was in John Smith's account. Maybe he got $60,000, $100,000, and no beneficiaries on the account. You don't have a will. You don't have a trust. That money is sitting there. Ain't nothing happening to it until legally a judge appoints how that money's going to be handled. So these are important. So let's take another question here. We have, is it better to have an irrevocable trust?
Favorite attorney's answer, it depends.
Yes.
Because it depends. Sometimes people come to me and tell me, oh, we need irrevocable trust. And they have one house and two bank accounts. I'm like, why do you need? Because somebody told me to. Yes, irrevocable trusts, as we discussed before, they do protect you, do have certain advantages, such as creditor protection, tax protection. However, it's not for everybody. Not everybody needs it. It is one of the planning techniques that we utilize when it's necessary. Usually it's for higher net worth and for older people or if you have your family history of illness. For example, you can foresee that, okay, I may be going down mentally or physically. If you have a history of heart attacks in your family, then you expect that you may need a long-term care. We can create those irrevocable trusts, transfer properties, and so it depends. It's so your family doesn't have to expend all of your savings that you saved for traveling the world, or you wanted to give it to your family. We can safeguard it and make sure that you still receive your long-term care benefits.
Great answer. Okay, here's another one. Would you ever recommend an offshore trust to a client? That's new.
Wow. Here is the multi-million-dollar coming. Well, it does happen as part of that asset protection technique. When we want to hide legally, again, offshore trusts, we can create the domestic irrevocable trust. It can be done through Delaware, Wyoming, I think. So some states that are extra protective of their people and businesses, or it could be offshore irrevocable trust. Again, it's done for asset protection purposes, and usually with huge amounts of money. And for that, I also involve other people who, it has to be a team, and it's very expensive, and it has to be maintained because you have to hire local person over there, almost have a business address in that offshore country. It is, but we can talk about it if you need assistance.
Yeah, and that also, you have to know who to trust offshore as well, because there's so much nefarious things going on in the world today. You don't want it to be going to, you think it's somebody that's a shield person, an AI person that's managing your money. And it ain't managing it at all. It's taking your money. So we just got to have wisdom in everything. Okay. So we have one. Do trusts only manage the money and assets? Can you add rules to the trust that the person must follow in order to access the money? Very good one.
That is the beautiful part of the trust. So some clients have such an imagination. They want to rule their beneficiaries from the grave to the, the tiniest details. So I had a family, one parent who wanted to make a child to make sure they finish not just high school. They have to finish college. They have to finish certain classes. They have to go to this church, and they have to do this and that.
Wow.
I'm like, it's hard. But yes, in reality, usually when we plan, when they're minor kids still, we planned like life insurance. God forbid something happens now. I want to make sure that my minor kid has money and resources to go through my young years, then through college or job, whatever their road's going to be. What we don't want to do, we don't want to sponsor kids. We don't want that. If there's no planning, your 18-year-old child will receive inheritance at legal age of 18 years old, that adult. And what's going to happen with the money? Most often it gets lost very quickly. Parties, business proposals, girlfriends, boyfriends, etc. So what we can manage, usually they say, hey, when you finish school, you can get something for your whatever needs. Then in 3 years, you can get this portion. In 5 years, or if you graduate, you can receive this percentage or portion.
As they mature.
As they mature, you're helping them. You're managing their wealth, so they still work, but they know that their parents took care of them, and there's still that wall behind you as a parent. They know that they have that peace of mind again. And but the story I tell all the time about my daughters, remember so my 16-year-old came to me and asked if I can get a tattoo, if she can get a tattoo. I'm like, of course you can, but be mindful that in my documents it's written that when you receive inheritance, you have to take a test at the dermatologist's office. And if they see there's tattoo or scar from tattoo removal, then your portion will go to your siblings. And she's like, Mom, you could have just said no. Well, I didn't do it, but it's an illustration that you could be as detailed as that. So it's up to you. Yes, you can control.
Yes.
And what is important, that joke, but what's very important is if you have a child or your future beneficiary who is not that well, either drug abuse or criminal activities, and if you're going to give money to this person, it's going to be wasted or it's going to be turned to some bad things. What you can do is create an incentive trust for that person. You can say, hey, dude, if you are sober, if you go through, rehabilitation, you can receive this amount. You can get it. If you get a job, your salary can be matched from the trust fund. If you clean from criminal activities, if you get a job, you get married, you can get this. So you intensify the person. You're giving you hope that, hey, if I do well, it's not only good for me, but I'm going to get money. I mean, somebody cared about me so much. Of course, they're going to be angry first, but it doesn't matter because it's good for them. It's good for them and their future.
I think it's also good for young children to have it be over a period of time, because when you're young, for those of us that's been young, you don't necessarily always have good money management skills, and you can waste. And I've seen people that have come into extreme wealth that people left for them in one way or another and just blew it. And it was like, oh my God, all that money, how did that happen? So I think for those of you that do have young children, this is something to really take into heart, that if you have anything, to graduate it at certain ages to where the mind is more developed and they can really handle and be more responsible. Because you don't know, when we're young, we think we know everything. We want to be grown at 10, you know what I mean, and don't really know. But let's take some more questions here. These are very good questions, you guys. Keep them
I love
coming.
your crowd.
We got 30 more minutes and we want to give you this information. And I want to remind each of you that if you need help with estate planning, or you have a trust and it needs to be reviewed and modified like mine's, Maria is offering 25% discount with the LYLWL 2023 code. You call them, you email them at their office, and you will get that discount on behalf of Living Your Life Without Limits. Okay? Do not forget that. I'll repeat it again before the end of the show. So, another question here. Do trust only oh, I already asked that one. The next one was, can you only have one trust or set up different ones for separate things?
Yes. I love you. Guys,
I think they did. I tell you, they sharp. Y'all sharp.
Very sharp. So yes, you can have multiple trusts for various reasons. For example, let's take a blended family, or even not, just a family. But let's say a husband has inheritance from his or her parents, separate house. So he wants to make sure that that house is goes to one way decisions on how it's going to be administered after his death, and then they have their joint house or assets. It goes to their kids or whatnot. So person can have joint trust as a family, or can have separate trusts for his or her separate property. And there could be separate trusts for specific property, let's say for one house, or for lots of land, or that multi-unit building. So one person can have multiple trusts, and can have. Remember, we were talking about irrevocable trusts.
Mhm.
So you can have one revocable trust to manage all of your ongoing business and life, and then separately irrevocable trusts to go make sure that there's no extra taxes, creditor protection, and future for the family.
Good. So the answer is yes.
Yes.
You can have multiple. All right, here's another one. Can the family vote the trustee out or overthrow the trust?
Well, we're talking about when person who created the trust already passed away.
Yes, I'm assuming that.
So
Trisha
again,
can clarify.
Trisha, usually after in the trust documents, it is written, spelled out, at least in my trust. Excuse me, can you bring me that book? Yeah, the trust. So this is the trust document that I create for my clients. So usually in the document, it is specified what family beneficiaries can or cannot do to remove the executor or the administrator of the trust, the successor trustee. And it depends. I don't know what's written. Read the trust and see what's in there. As I told, it could be by vote of beneficiaries. Hey, you're not doing the job. We don't like you. Get out. It could be with or without cause. Sometimes it has to be with the cause or without cause. It depends what's in the body of the document. And about canceling trust, it is also possible if all the beneficiaries come together. Usually should be done through the attorney, so there's official language about it. Came all together and decide, hey, we don't want this trust. We want to just cancel it out. We all agree. We all understand. We that's what we want. It is a possibility. I'm not telling you.
So it can happen.
Potentially.
Potentially. Yes. Okay. So basically, because the trust is your will and you put these stipulations in it, there's various ways it can be performed.
Absolutely.
It takes you, taking the first step to sitting down with somebody to help you craft it. where you look at all different scenarios and angles to them. Because if it's done incorrectly, it can also be the worst thing that has happened, where it can still be held up in some kind of way.
Yeah.
Or you have loopholes where people can go in and do it. So we have a couple of other questions here. How does the trustee's role different when managing an irrevocable trust that holds business ownership? I like that one. Yeah.
Irrevocable trust business ownership. Well, for that, when you create an irrevocable trust, you have to appoint somebody else other than the grantor as the trustee. So you, as person who established the trust, don't necessarily have control over management of the trust. So it's basically like you giving away management of your company to manage to somebody else to do it for you, and making those business decisions and overseeing the trust, because they have to act in the interest of the beneficiaries. So I necessarily depends on the business again. We have to. I'm not sure if this can be recommended. It's very depending question, depends on the facts, what kind of business structure. If you're sole manager, sole owner, or their partners, other partners may not agree to put it in.
Sure.
Whose irrevocable trust is that? So it depends. By the way, I have to put a little disclaimer. I didn't do none of this constitutes legal advice. We're just talking about possible scenarios and what
you're not a representative.
What can be done in
each case could be different. Yeah, these are general things and good questions that are coming out. So the follow up to the business one is: are there any restrictions on transferring ownership or selling a business that is held within an irrevocable trust?
Of course, it is irrevocable trust, and usually it is set up for future. So, and again, we have to read what's written in the body of the trust. If creator of the trust allowed possible decanting is a legal word calling for canceling, changing or canceling the irrevocable trust. So again, it depends.
So that's probably going to address this follow. It can be dissolved or terminated if there's a decanting.
If there's
added to the terminology
again,
in the
because
word.
sometimes if business goes sour, it doesn't produce anything, then everybody can, it's a business decision, because there is no reason to keep this trust going because it doesn't produce anything or it doesn't make sense. Then, or sometimes they put it, the value of the asset goes below certain number, we can close it.
So should a person have, if they have a business, do you lump it all together with your personal assets, or you create them separately? What would you recommend?
Okay. Depends.
Okay.
Type of business, value it produces. Business, okay, let's take standard situation. So there's a house, a family house, and there's business. Business, usually it's in a corporation or LLC, depends. Usually what we do, very important for listeners, viewers who,
especially small businesses and self-employed.
If you have business and it's in LLC or corporation, make sure, because we can create this beautiful trust and put your house in it, and if we don't reference the business, what's going to happen with your business if you pass away, especially if you have partners? So you have to take a close look at your operating agreement, and if it's a corporation, bylaws, what's written in it. Look for the succession. Make sure there is some verbiage saying, hey, if a member or the owner passes away, becomes incompetent, what happens to his or her share or membership interest? What's happened to it? Because if we don't address it, we're back in probate court and the whole purpose is defeated. So we have to take a look at the corporate books. That's what I do, and make sure. So what we usually do in standard situation is to transfer interest in that LLC to the trust.
What if it's a corporation and not either one,
Same,
whichever?
same.
Okay.
Yeah. So you
look at the bylaws of the business to construct how the direction you're going to go with the trust. That's a very good question.
And we can change bylaws or amend it, because usually, what does it take to create a corporation or LLC? People go either online themselves or LegalZoom or other platforms to click, no thinking involved, just they spit out the document. If you go directly to Secretary of State website, you can form a corporation or LLC, but none of the supporting documents are there. So you have to create your own bylaws. You have to create your own corporation, and it is very important.
I do know we're dealing with the federal government because we got 8A, SBA certified. They had you put in to make sure if you didn't have it. One of the things is that you have to have a successor identified, so that if anything happens to you, to just do contract business with them, life goes on. You got a commitment with us. So if you fall off the face of the earth, I can't do the job.
Yeah.
Who is going to run this? So to get a contract just with the federal government, you had to list who is going to be running the business should you not be able to do it.
Absolutely.
So it makes a perfect sense with everything else. Okay, so here's one. Have you ever set up a special needs trust for children with special needs? This is very good. Yeah, it's very good, because what happens to those sometimes get forgotten?
No, hopefully they're not forgotten. So yes, very important. We look into, what type of disability. Is it permanent? If we're talking about autism or mental disorder, is it functional? What do you foresee for your child if he or she is it possible to become a productive adult or not, or not what level? That's how you manage. Yes, we do set up a special needs trust either within the document itself. So we say, if I, as a parent, if and when I pass away, I give my child, let's say we have two kids that's are okay, and one with special needs. So we can have separate planning for one kid and separate planning for special needs child. And we say, if I die, you will not receive your lump sum or whatever inheritance right away, to make sure they're not getting kicked out from government programs that support their health activities or everyday
you have to have a
activities,
certain income level,
or anything. So we make sure that we set up the way that it doesn't affect their life, and we create we appoint the trustee who will manage it. So it could be done either within the body of your trust, or it can be set up separate kids special needs trusts. Again, we talk about it, what's the best option for you.
That segues me into this question before we take another one. So it could be for seniors, because a lot of seniors work very hard, and when they get on Medicare, I don't know if you guys know this, and you access your Medicare and you have property, you could either have to, at the end of your life, they can come and put a lien on your assets.
Medi-Cal.
Medi-Cal? What about Medicare?
Medicare is good.
No, okay. But Medi-Cal, they can do that and put a lien on your assets, and you have to pay that money back. So I know that a lot of seniors go to trust to protect their assets.
Yes,
because they don't want these things when they access federal funding. So not Medicare, only Medi-Cal?
It's Medi-Cal, and because Medicare doesn't cover long-term care.
Okay.
They cover only up to 90 days of your extended
skilled
care. That's why they're not as worried about it.
Okay.
But it used to be a very huge thing, but now California did some good things. Yes, so they've raised the limit from 2,000 to right now I think 130,000.
Okay.
And in the future, they're not going to be limits on the property that you own.
Wonderful.
So
Because it's
something
terrible that
something
people lose their property
Yes.
because of that.
yes. So
Okay,
so
good.
something good's been done by our government.
And it may vary from state to state.
Oh
going
yes,
forward,
oh
yeah.
yes. For other states are very. It is very important, and people plan for it. And they have 5-year look back period. For now, we have 3 years look back period for the California. But now at this point, it's still somewhat relevant. So if you have the concern long term care, we should talk still.
So how will wills or trusts address incapacity planning, such as medical decisions and managing finance? This is a great one, and we actually covered this in great detail in the one that's already on the YouTube, but I'm going to have Maria answer it. And a part of that trust is not just the financial. She goes through all of that, the healthcare part of it as well. There's a whole questionnaire that she goes over that, the healthcare, and having people be able to act on your behalf. So you wanna
Yes.
talk about
So of course, it's a gift. Even if you don't have anything, your 18-year-old adult have to have power of attorney, healthcare directive, and HIPAA forms. Power of
So
attorney.
if nothing else, if you feel you got $1 to your name and you don't own nothing, don't want to leave nobody nothing, but you are in a position where, heaven forbid, you are unable to act on your own behalf. You're in the hospital, you're in a coma, you are incapacitated temporarily. You need the minimum of what now?
Power of attorney.
Power of attorney.
For financial and legal matters.
Okay.
Healthcare directive.
Healthcare
for
directive.
medical decisions.
Absolutely.
And HIPAA forms, so those medical providers can disclose your
Exactly.
protected medical information.
So anybody 18 or over, please at least have those 3 forms for yourself so that you can make sure you giving people access to help you in these difficult times.
Yeah.
I will tell a quick story because we're going to answer a few more minutes. I had an aunt who I love, one of my favorite aunts, absolute favorite aunts. I don't even know if she's on here now, but she fell sick, unfortunately, with an ear infection that went into a sepsis, and she was out for months. And it was a struggle for her sister to be able to do business on her behalf because nobody had access to anything. So things can happen. Thank God she survived it. She's thriving and she's doing well. And one of my favorite aunts, I want to add. But just that quick, somebody who's healthy, who is viable, and had an event happen and was locked out, and nobody could do business for her. So it can happen. And that's why we brought this back live, because we know today, we don't know what can happen an hour from today, let alone tomorrow. So I want to make sure my people are whole, not just in your mind, but this is going to give you peace of mind that know that somebody is going to act as an agent on your behalf should you not be able to be that voice for yourself. And guess what? Make sure you choose wisely. Not choose somebody from friend to kin, but somebody who is responsible and accountable and have your best interests at heart. Because if not, that will be disastrous for you. So please, don't just choose because you love them or their kin or friend, but choose somebody who is going to take that position seriously and have ownership and accountability to it. All right, I'm going to take a few more questions, and then we're going to have a final wrap up from Miss Maria today. Okay, so how are minor children guardianships cares addressed in a will versus a trust? Probably the same, but
Yeah, usual. So this package, if we create a trust, contains also a will, as part. It's called pour over will. It's in detail. So, and in that will, we address, we put guardians again, 1, 2, 3, who we trust in the order, just in case. And we put, when minor children are involved, I prefer my clients to choose separately one person as a guardian who takes care of health, education, everyday churches, activities, vacations, everything, and another person who is in charge of finances. So these two people act separately, and again, can control it and check each other.
Check and balances.
Checks and
I like that.
balances. So the guardian is usually named in the will, and the financial person in a body of the trust, and also power of attorney can reference a guardian as well. So it's all in there. Also, I do provide temporary guardianship forms for you. So let's say you're alive, but illness happened, or you're out of country, whatever. You're not here to take care of your child, or accident happened. So you have that temporary guardianship form that you keep in your glove compartment at day care, at school. So persons there, if you're not coming to pick up your child, there is next person named, and school has legal authority to release child to this person.
Good. Okay, here's one of our final questions here before we summarize here. Can a will and a trust work together in a estate plan, or must you choose one over the other?
Well, it is part of the complete planning, will
Okay.
and trust. But during our meeting, we'll decide which one will work for you. If you need separate, if there's trust, we create will just in case as a backup. It's called pour over will, meaning if trust doesn't work for some reason, there's backup, and will says no, we still want everything in the trust, and trust still governs. So, but there could be no need for a trust if you don't have property. Then you don't need a trust.
Maybe
then
just a will.
Just a will, it's sufficient. So that's okay.
So that answers your question, Candace. Should you have both? And it just depends, but you can have both.
Yes. When I create trust, there is a will. Okay, for sure.
Now, there's one that came earlier today that came through email, and I'm going to make that the final question here, and then we're going to give out Maria's information for everyone and remind them the cost. It was, what if you have it and you didn't fund it with any of your assets? What happens to that? You have a trust, but you didn't fund it. You wrote it, but you never put anything in it. And how do you fund it? That's
Remember the first time we've met?
Yeah.
And there was a lady that came from the first show.
Yes.
That's exactly what happens. She brought me beautiful documents.
This is a real story of somebody that came from Living Your Life Without Limits that got that 25% discount before. So I'm going to start that. Okay, go ahead.
So she brought me beautiful documents. Their mother passed away, and she's like, oh, we have a trust. Just can help us administer it. Well, I looked at the trust. It was okay. Decent trust document. They paid good amount of money for it, but when I
way more than what Maria charged. But go ahead.
But when I looked at the title and looked at the assets that were supposed to be included in the trust, it was not. They were not named in the trust, and we're still in probate. It's been like 2 years, more than 2 years.
So this was created before Maria, but the trust was never funded. I know this case very well. So it's important to fund the trust, meaning that the title and the assets have to be named, transferred into the trust in order to receive the protection of the trust. Am I right about it?
Absolutely.
And when you don't do that, it's just a document that looks good and pretty, but still going to probate. So the only time you would not want to do that, in case where you're unsure that you want the people that you're originally in there, you're going to make a change, which is in case what I did is that the first one, I had it in one way, did not fund it. And now that things are more clear, as they say, I can see clearly now, the rain is gone. It's going back again where the assets will go into the trust. So, as we're closing this out, I hope you enjoyed this because this was brought with intention for my people. And as I said, there's a scripture that said, my people perish because of lack of knowledge. And too many, guess who's filling up the probate? A legal department, African Americans and Hispanics. We are flooded in there because no one is bringing this type of knowledge to us to let us know that we, in the little we have, because everybody think you got to be a millionaire or billionaire to have a trust. And that is not the case. So it was important to me that I bring these subjects forward because it's also about health. And financial health affects your mental health. Can I get a witness? It does. So here is Maria's office number. And they're very friendly here. And it's 818-788-7881. 818-788-7881. Or you can visit them at MVP.com, isn't it?
MVP Law LA.
MVP Law LA.com. And if you forget all of that, hit me up on Instagram or call or email me at info@livingyourlifewithoutlimits and I'll give it to you again. And if you use the code LYLWL 2023, you will receive a 25% discount. And that can go a long ways. Whether you're doing something of a modification or them 3 documents or a full big package, or you got them 12 million plus, it applies to all. And I hope that you take this to heart. And if you don't need it, pass it on to anybody, because that code can be used for everybody that is invested in getting their lives together. Maria, leave the audience with one final thought before I sign off with my signature sign off.
Well, first of all, Shannon, thank you so much for bringing it up and giving me another platform to educate people, your people, our people, just people.
My people, my family.
Our family. It's because it hurts me to witness what's going on, that people who can afford and have the knowledge, they somehow take, not always, by the way, take care of themselves. But I want at least to give your education knowledge. Now you can make your informed decision if you're protecting your family, or you say, no, I know all about it, but I don't want to do it. That's totally fine too. But now you know. And as part of that package, so we can, I also give for the audience free consultation, so we can talk. Because every
case is different.
As I said numerous times, it depends. So we can talk about your particular fact pattern and see what's the best option for you. And it's a half an hour included consultation. And just be responsible for yourself in your life. It's you. It's you. It's your decision what's going to happen to you, your wealth, your children, your family, the future. So your future depends on the decisions you make today. So make that right decision and have peace of mind.
That is a wrap for us. So remember, family, thank you once again for tuning in. And if you missed any part of it, it is going to be on the YouTube channel. And as I always end no different. Remember, family, to love yourself. Take care of yourself. Because guess what? You are absolutely worth it. Thank you for tuning in to another episode of Living Your Life Without Limits. And I'll see you next week.